So, one of the most frequently asked questions I have been getting since July 1st is, do I still need to use the instructions to closing attorney with my transactions? Hi, everybody. Dana Sparks, broker of Maximum One Greater Atlanta Realtors and director of the Real Estate Academy of America. And today's video tip is about the poor form instructions to closing attorney, the Georgia Association of REALTORS form. And since GAR's revision of the July 1st release of the revision of their contract package, which has included revisions to a lot of the compensation forms, the new or the revised, altered, clarified compensation sections in the buyer agreements and in the seller agreements, as well as the revised and reworked pre-showing compensation agreement and the new exhibit agreement for broker compensation, as well as the special stipulation that addresses compensation that has been in the GAR package since January of this year. The question is, and they did rework instructions to closing attorney. Please check out the video. I will link it below that I have done a full video on that form and how to fill it out. But the question is, with all these additional new revised compensation forms, now that the NAR preliminary settlement is in effect, I am recording this July of 2024. Do I still need instructions to closing attorney? If I already have compensation addressed, signed, agreed upon, negotiated in other forms, why on earth do I need that form? Or do I need that form? Well, stay tuned to the end and I'll give you the answer, but let's backtrack a little bit. So, generally speaking, the seller compensates their broker by virtue of what has been negotiated and agreed upon in the seller brokerage agreement or authorization to show unlisted property, depending upon if you're working with the public person as a client or a customer. The buyer's obligation to their broker is negotiated and agreed upon in the buyer brokerage agreement or the acknowledgement agreement to work with broker as customer. So the outset of the compensation to their own brokers, those are the forms where that is agreed upon, signed, and documented. Now, generally speaking, a seller's broker gets paid by the seller. A buyer's broker, however, can get paid one of three ways: by the buyer directly, by the seller directly, or by the seller's broker in a co-op compensation transaction. What we have done for many, many, many years. Now, depending upon how all of that gets negotiated between and among all of the parties, there are other forms. And please check out the playlist, the 2024 GAR contract playlist, the contract revisions playlist, and the NAR settlement playlist. I've got tons of videos addressing all of those, as well as recorded CE classes addressing those. But the point is, there could be a situation in any one transaction where compensation has already been addressed using a number of forms. What about the poor instructions to closing attorney? Is that just cast out like an old friend? Is it no longer a relevant form? Or is it still a relevant form? Or is it just old news? Well, the answer is, it is still a relevant form. And here is why. There is a situation, potentially, where it is required, because that is the only form with signatures where compensation is negotiated and agreed to in writing. For example, if a buyer's broker is getting compensated in a co-op transaction from the seller's broker, already been approved upon by both the public buyer and the public seller in their agreements, but the actual negotiation for the money it's coming from one broker to the other broker. That hasn't been signed yet. So in that situation, you absolutely would need, if there's nothing else signed, you would need the instructions to closing attorney with both broker/agent signatures. That would be the only place that you would have that negotiation written and agreed to and signed with signatures on the instructions to closing attorney. Now, there is a place on the revised instructions to closing attorney where the seller signs. The seller does not have to sign that unless the seller is compensating the buyer's broker directly. Again, refer you to that video where I've done a full explanation on that form. However, so in that situation, it's required. However, I highly suggest and encourage, always check with your own broker if you're not a maximum one agent, but I highly suggest and encourage that you use your instructions to closing attorney regardless of any other form signed by the parties agreeing on compensation to be paid to the brokers. Why? Well, it is a good summary. It is a good one-page summary of the compensation to the brokers to summarize if those funds, fees, payments have been negotiated, agreed to, and signed on another form, either in the purchase and sale agreement, in an exhibit, in a pre-showing compensation agreement. It is still a good idea to use the instructions to closing attorney to summarize all of the compensation to the brokers, how much it is, and who is paying which broker, what party is paying, basically the buyer's broker, and how much. Number one, your closing attorneys are really used to looking at, or your pre-closers are really used to looking at that one form so that they don't miss something. They don't have to look at this form and that contract and this form. Remember, your pre-showing compensation agreement, that's not a part of the contract. That's a separate agreement. So if for whatever reason the closing attorney didn't get that or the pre-closure doesn't know to look at that, again, the instructions to closing attorney is just a good summary of the compensation, who is paying how much. Your closing attorneys are used to looking at that. And please do your brokers and your compliance brokers a favor. We need that as a summary too, so that we don't miss anything in our compliance checks of your contracts. And it's just a good exercise for you agents on both sides of the deal, you buyers agents and sellers agents, to make sure that the negotiations have been, are what you think they are, and they have been done correctly. Just like you get a preliminary closing statement before closing, and you review that to make sure all the other terms of the contract that had been negotiated between the buyer and the seller are correct. Think of the instructions to closing attorney if compensation had been agreed upon in other forms. Think of that as just a summary and a check to make sure it is all done and negotiated correctly. Additionally, you absolutely need that form if there are any rebates going back from either broker to the buyer or the seller, and if there are any referral fees that need to be paid. That is all itemized on page 2 of the Georgia Association of REALTORS, or GAR, instructions to closing attorney that was revised in July. So, instructions to closing attorney, still relevant form or old news? My position is it's absolutely still a relevant form and an old friend, and make sure you treat that form like an old friend. And I highly suggest, encourage you to use it in all of your transactions. What do you think? Comment below. I'd love to hear your thoughts. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.